What's going on? What's going on, Roots? What's going on? Welcome to the chat. What's going on, John? So today, I'm going over land condemnation proceedings. So we have Rule 71.1. This is out of Federal Rules of Civil Procedure. Now, I'm not saying this is the answer. I'm just saying it's important to know how we got here. So, it's important to understand that when certain things, certain securities have, they're tied to certain lands that have been annexed, then, how the rules that they have to comport to in order to issue those securities sometimes is under Rule 71.1. So it says here, applicability of other rules. These rules govern proceedings to condemn real and personal property. Notice it says real and personal property by eminent domain, annexation, except as this rule provides otherwise. Joinder of properties. So it says real and personal, right? So what if they conjoined the real and the personal? So personal intangibles and real collateral. So the plaintiff may join separate pieces of property in a single action, no matter whether they are owned by the same persons or sought for the same use. Complaint. The caption. The complaint must contain a caption as provided in Rule 10a. The plaintiff must, however, name as defendants both the property, designated generally by kind, quantity, and location. Maybe that's height, weight, maybe if it's some other type of immovable, its meets and bounds, its landmarks, who the sole beneficiaries are, and at least one owner of some part or interest in the property, the true owner. Contents. The complaint must contain a short and plain statement to the following. A. The authority for the taking. B. The uses for which the property is to be taken. C. A description sufficient to identify the property. D. The interests to be acquired. And E. For each piece of property, a designation of each defendant who has been joined as an owner or owner of an interest in it. 3. Parties. When the action commences, the plaintiff need join as defendants only those persons who have or claim an interest in the property and whose names are then known. But before any hearing or on compensation, the plaintiff must add as defendants all those persons who have or claim an interest and whose names have become known or can be found by reasonably diligent search of the records, considering both the property's character and value and the interests to be acquired. All others may be made defendants under the designation unknown owners. Procedure. Notice must be served on all defendants provided in Rule 71.1d, whether they were named as defendants when the action commenced or were added later. A defendant may answer as provided in Rule 71.1e. The court, meanwhile, may order any distribution of a deposit that the facts warrant. Filing and additional copies. In addition to filing the complaint, the plaintiff must give the clerk at least one copy for the defendant's use, and additional copies at the request of the clerk or defendant. Process. Delivering notice to the clerk. On filing a complaint, the plaintiff must promptly deliver the clerk joint or several notices directed to the named defendants. When adding defendants, the plaintiff must deliver to the clerk additional notices directed to the new defendants. Contents of the notice. Main contents. Each notice must name the court, the title of the action, and the defendant to whom it is directed. It must describe the property sufficiently to identify it, but need not describe any property other than that to be taken from the named defendant. The notice must also state that the action is to condemn property, the interest to be taken, the authority for taking, the uses for which his property is taken. The defendant may serve an answer on the plaintiff's attorney within 21 days after being served with the notice, that the failure to serve an answer constitutes consent to the taking, and to the court's authority to proceed with the action and fix the compensation. And that a defendant who does not serve an answer may file a notice of appearance. Conclusion. The notice must conclude with the name, telephone number, and email address of the plaintiff's attorney and address within the district in which the action is brought where the attorney may be served. Serving the notice. Personal service. When a defendant whose address is known resides within the United States or a territory subject to the administrative or judicial jurisdiction of the United States, personal service of the notice without copy of the complaint must be made in accordance with Rule 4. Service by publication. A defendant may be served by publication only when the plaintiff's attorney files a certificate stating that the attorney believes the defendant cannot be personally served, because after diligent inquiry within the state where the complaint is filed, the defendant's place of residence is unknown, or if known, that it is beyond the territorial limits of personal service. Service is then made by publishing the notice once a week for at least 3 successive weeks in a newspaper published in the county where the property is located, or if there is no such newspaper, in a newspaper with general circulation where the property is located. Before the last publication, a copy of the notice must be mailed to every defendant who cannot be personally served, but whose place of residence is then known. Unknown owners may be served by publication in the same manner by a notice addressed to unknown owners. Service by publication is complete on the date of last publication. The plaintiff's attorney must prove publication and mailing by a certificate, attached a printed copy of the published notice, and mark on the copy of the newspaper's name and the dates of publication. Effective delivery and service. Delivering the notice to the clerk and serving it have the same effect as serving a summons under Rule 4. Amending the notice. Proof and service amending the proof. Rule 4A2 governs the amending the notice. Rule 4L or I, I'm not sure, governs proof of service and amending it. Appearance or answer. Notice of appearance. A defendant that has no objection or defense to its taking of its property may serve a notice of appearance designating the property in which it claims an interest. The defendant must then be given notice of all later proceedings affecting the defendant. A defendant that has an objection or defense to the taking must serve an answer within 21 days after being served with the notice. The answer must identify the property in which the defendant claims an interest, state the nature and extent of the interest, and state all the defendant's objections and defenses to the taking. Waivers of other objections and defenses. Evidence on compensation. Defendant waives all objections and defenses not stated in its answer. No other pleading or motion asserting an additional objection or defense is allowed. But at that trial, on compensation, a defendant, whether or not previously appeared or answered, may present evidence on the amount of compensation to be paid and may share in the award. Amending pleadings. Without leave of court, the plaintiff may, as often as it wants, amend the complaint at any time before the trial on compensation. But no amendment may be made if it would result in a dismissal inconsistent with Rule 71.1 I, 1, or 2. The plaintiff need not serve a copy of an amendment, but must serve notice of the filing as provided in Rule 5b in Rule 71.1d on every affected party who has not appeared. In addition, the plaintiff must give the clerk at least one copy of each amendment for the defendant's use, and additional copies at the request of the clerk or defendant. Defendant may appear or answer in the time and manner with the same effect as provided in 71.1e. Substituting parties. If a defendant dies, becomes incompetent, or transfers an interest after being joined, the court may, on motion and notice of hearing, order that the proper party be substituted. Service on the motion and notice on a non-party must be made as provided in Rule 71.1d3. Trial of issues. Issues other than compensation. In an action involving an eminent domain under federal law, the court tries all issues, including compensation, except when compensation must be determined by any tribunal specially constituted by a federal statute or to determine compensation, or if there is no such tribunal, by a jury when a party demands one within the time to answer or within any additional time the court sets, unless the court appoints a commission. Appointing a commission. Reasons for appointing. If a party has demanded a jury, the court may instead appoint a 3-person commission to determine compensation because of the character, location, or quantity of the property to be condemned and for other just reasons. Alternate commissioners. The court may appoint up to 2 additional persons to serve as alternate commissioners to hear the case and replace the commissioners who before a decision is filed, the court finds unable or disqualified to perform their duties. Once the commission renders its final decision, the court must discharge any alternate who has not replaced a commissioner. Examining the prospective commissioners before making its appointments, the court must advise the parties of the identity and qualifications of each commissioner. Okay. Powers and report. Any action by the plaintiff, no compensation. not acquired, the plaintiff may, without court order, dismiss the action by stipulation, by court order, deposit in its distribution. The plaintiff must deposit with as a condition to the exercise of eminent domain and may make a deposit when allowed by statute. Distribution. Adjusting distribution. After a deposit, the court and attorneys must expedite the proceedings so far as to distribute the deposit and determine to pay compensation. If the compensation finally awarded to a defendant exceeds the amount distributed to the defendant, the court must enter judgment against the plaintiff for the deficiency. If the compensation awarded to a defendant is less than the amount distributed to that defendant, the court must enter a judgment against the defendant for the overpayment. Condemnation under a state's power of eminent domain. This rule governs an action involving eminent domain under state law. But if state law provides for trying an issue by jury or for trying the issue of compensation by jury or commission or both, that law governs. So yeah, this has stuff in there. However, because of the time frame, what's going on? I don't think it applies. So it said that after 21 or 3 consecutive publishings, that they can condemn the property. Most times people don't read or understand, what is going on by that time, and by that time it's already been condemned. The actual articles might fall under provisions under securities or securities entitlements, but you're dealing with annexed parcels of land with securities attached there too. So a lot of times. So that's something to be aware of. So it is the use of eminent domain. So let me see, serving the notice. Must serve an answer within 21 days. So most people have long since passed that deadline. So that's not usually the case. But it is important to understand what it is. So since we were on to defendants who failed attempted joinder. No, it's because of the joinder of the SS5 and other stuff. Yeah, they had to condemn it. And then it becomes under the use of emergency powers. Once it's under emergency powers, then it changes nature and it ports in venue and in law form. So, yeah, but provides some insight as far as how it happened, why it happened, and it didn't say that state law governs it after a certain point, but they had to comport to the federal rule. So yeah. Let me see. Yeah, after 21 days, yeah, joinder becomes automatic because of condemnation. So when people are saying, "Oh, that's not me and that's not me," you still the surety for it, so it don't matter until you correct the main issue. Most people are arguing a moot point. So let me see. So this is out of Blackstone's Commentaries on the Laws of England, Book the 2nd, Chapter 13th, of the title to things real in general. So it says, in general. Let me just turn it sideways. So foregoing chapters have been principally employed in defining the nature of things real, in describing the tenures by which they may be holden, and in distinguishing the several kinds of estate or interest that may be had therein. Yeah. I come now to consider, lastly, the title to things real, and with the manner of acquiring and of losing it. A title is thus defined by Sir Edward Coke. Titulus est justa causa possidendi id quod nostrum est. I don't know what that translates to. It's a little bit more than my Latin studies. Title what titulus est justa causa possidendi id quod nostrum est. So in legal terms, it means that the title or the proof of ownership is a legitimate reason why someone can possess a piece of property, as it establishes their rightful claim to it. So yeah. Or it is the means whereby the owner of lands hath the just possession of his property. There are several stages or degrees requisite to form a complete title to lands and tenements. We will consider them in a progressive order. The lowest and most imperfect degree of title consists in the mere naked possession. I feel like because it's dealing with land condemnation, with mineral rights and other interests, so derivative interests, I believe that until you address the root cause, it's not gonna do anything, which is why only certain means of ownership, corporate, estate settled in trust, things like that. The problem is The mother and father do. The mother and father do actually hold title. So you're with people, you know, where their parents are unwilling to help correct the situation. They are unwittingly continuing and perpetuating what the state is, you know, under parens patriae enforcing. So unfortunately, they do have they do have a valid signature on your behalf. It says the lowest and most imperfect degree of title to lands and tenements. The issue is the conveyance of lands. Regardless of whether you revoke the power of attorney, the revocation of the power of attorney will not change the grant of lands. So you have to reconstrue and withdraw your lands, tenements, and hereditaments and redeposit them to form a constructive trust. So, right, but it's because, like I said, look at the 1483 Act by Richard III. All transfers and conveyances against the cestec use held as good. And you'll understand why. So, alright, so the most imperfect degree of title consists in the mere naked possession or actual occupation of the estate, without any apparent right, or any shadow or pretense of right, or any shadow or pretense of right to hold and continue such possession. This may happen when one man invades the possession of another, and by force or surprise turns him out of the occupation of his lands, which is termed disseason, being a deprivation of the actual season or corporeal freehold of the lands which the tenant before enjoyed. Yeah, withdraw the general deposit so that it's no longer construed as under a general bailment, and then redeposit it as a special deposit or trust deposit. Yeah. Or it may happen that after the death of the ancestor and before the entry of the heir, or after the death of a particular tenant and before the entry of him in remainder or reversion, a stranger may contrive to get possession of the vacant land and hold out to him that had a right to enter. What's going on, Silent Walk? Yeah, but like I said, you have to get the title you have to get the titles, and then you have to merge the titles and then wind up the trust. You know, it's not collapsing the trust. You want to wind it up. So, you know, you have to do that. That's the only way. So, yeah. Right, but here's the problem. Mentally incompetent are under the auspices of the feudal lord or the state. So it doesn't matter what you want to do until you prove yourself competent. Remember, we're not under American law. We're under British. You're guilty until proven innocent. Incompetent until proven competent. On wrongdoer, and hold him out of right and to enter, in all which cases and many others that might be here suggested, the wrongdoer has only a mere naked possession, which the rightful owner may put an end to by a variety of legal remedies, as will more fully appear in the third book of these commentaries. But in the meantime, till some act be done by the rightful owner to divest this possession and assert his title, such actual possession is prima facie evidence of a legal title in the possessor, and it may, by degrees, ripen into a perfect and indivisible title. And at all events, without such actual possession, no title can be completely good. It's not about that. It's about merging the two contracts. It's about withdrawing those two contracts and depositing them with the right trustee, to where the old trust winds up and it's a new constructive trust is formed in your favor, according to the right of disposition, grantor's right of disposition. The next step to a good and perfect title is the right of possession, which may reside in one man, while the actual possession is either in himself or another. For if a man be deceased, or otherwise kept out of possession, by any of the means before mentioned, though the actual possession be lost, yet he has still remaining in him the right of possession, and may exert it whenever he thinks proper, by entering upon the deceiser and turning him out of that occupancy which he has so illegally gained. But this right of possession is of two sorts: an apparent right of possession, which may be defeated by proving a better, and the actual right of possession, which will stand the test against all opponents. Thus, if the deceiser or another wrongdoer dies possessed of the land whereof he so became seized by his own unlawful act, and the same descends to his heir, now the heir hath obtained an apparent right, though the actual right of possession resides in the person disseized. And it shall not be lawful for the person disseized to divest this apparent right by mere entry of the other act of his own, but only by an action at law. For until the contrary be proven by legal demonstration, the law will rather presume the right to reside in the heir whose ancestor died seized, than in one who has no such presumptive evidence to urge in his own behalf. Correcting the record and merging the titles. Beneficial use and equitable interest. It's not just beneficial use and equitable interest, it's legal title and equitable interest. Until you construe it otherwise, John, yeah. But after you construe it to be another type of entity, it's identity theft. So, which doctrine in some measure arose from the principles of the feudal law, which after feuds became hereditary, much favored the right of the descent, in order that there might be a person always on the spot to perform the feudal duties and services. And therefore, when a feudatory died in battle, or otherwise, it presumed always that his children were entitled to the feud, till the right was otherwise determined by his fellow soldiers and fellow tenants, the peers of the feudal court. But if he, who has the actual right of possession, puts in his claim and brings his action within a reasonable time, and can prove by what unlawful means the ancestor became seized, he will then, by sentence of law, recover that possession, to which he hath such actual right. Yet if he omits to bring this his possessory action within competent time, his adversary may imperceptibly gain an actual right of possession, in consequence of the other's negligence. And by this and certain other means, the party out of possession may have nothing left in him. But what we are next to speak of is the mere right of property, jus proprietatis, without either possession or even the right of possession. This is frequently spoken of in our books under the name of the mere right, jus merum, and the estate of the owner is in such cases said to be totally divested and put to a wreck. A person in this situation may have the true ultimate property of the lands in himself, but by the intervention of certain circumstances, either by his own negligence, the solemn act of an ancestor, or the determination of a court of justice, the presumptive evidence of that right is strongly in favor of his antagonist, who has thereby obtained the absolute right of possession. As in the first place, if a person deceased or turned out of possession of his estate neglects to pursue his remedy within time limited by law, this means the deceasor or his heirs gain the actual right of possession. For the law presumes that either he had a good right originally, in virtue of which he entered on the lands on question, or that since his entry he has procured a sufficient title, and therefore, after so long an acquiescence, the law will not suffer his possession to be disturbed without inquiring into the absolute right of property. Yet still, if the person deceased or his heir hath the true right of property remaining in himself, his estate is indeed said to be turned into a mere right. But by proving such his better right, he may at length recover the lands. Again, if a tenant in tail discontinues his estate tail by alienating the lands to a stranger in fee and dies, here the issue in tail hath no right of possession, independent of the right of property. For the law presumes prima facie that the ancestor would not disinherit or attempt to disinherit his heirs unless he had power so to do. And therefore, as the ancestor had in himself the right of possession and has transferred the same to a stranger, the law will not permit that possession now to be disturbed unless by showing the absolute right of property reside in another person. The heir, therefore, in this case, has only a mere right, and must be strictly held to the proof of it, in order to recover the lands. Lastly, if by accident, neglect, or otherwise, judgment is given for either party in a possessory action, that is, such wherein the right of possession only, and not that of property, is contested, and the other party hath indeed in himself the right of property, this is now turned into a mere right, and upon proof thereof in a subsequent action, denominated a writ of right, he shall recover his season of the lands. Thus, if a deceasor turns me out of possession of my lands, he thereby gains a mere naked possession, and I still retain the right of possession and the right of property. If the deceasor dies, and the lands descend to his son, the son gains an apparent right of possession, but I still retain the actual right of possession and property. If I acquiesce for 30 years without bringing an action to recover possession of the lands, the son gains the actual right of possession, and I retain nothing but the mere right of property. And even this right of property will fail, or at least it will be without a remedy, unless I pursue it within the space of 60 years. So also, if the father be tenant in tail, and aliens the estate tail to a stranger in fee, the alienee thereby gains the right of possession, and the son hath only the mere right or right of property, and hence it will follow that one man may have the possession, another right of possession, and third the right of possession, and issue entail of the right of property. A may recover the possession against B, and afterwards the issue entail may evict A and unite himself the possession, the right of possession, and also the right of property, in which union consists a complete title to lands, tenements, and hereditaments. For it is an ancient maxim of the law that no title is completely good unless the right of possession be joined with the right of property, which right is then denominated a double right, jus duplicatum, or droit. And when to this double right the actual possession is also united, when there is, according to the expression, fleta juris et seasinae conjunctio, and then and only then is the title completely legal. Yeah. Let me look at that. Slater. Conjunction of right and season. That's what it means. So, yeah. So there you go. Lands, tenements, and hereditaments. Let's look at things personal. They say it's not personal. Blackstone's Commentaries on the Laws of England, Book the 2nd, Chapter 24 of Things Personal. Under the name of things personal are included all sorts of things movable, which may attend a man's person wherever he goes, and therefore, being only the objects of the law while they remain within the limits of its jurisdiction, and being also of a perishable quality, are not esteemed of so high a nature, nor paid so much regard to by the law, as things that are in their nature more permanent and immovable, as lands and houses and profits issuing thereout. Yeah. These being constantly within the reach and under the protection of the law, were the principal favorites of our first legislatures, who took all imaginable care in ascertaining the rights and directing the disposition of such property as they imagined to be lasting, and which would answer to posterity the trouble and pains that their ancestors employed about them, but at the same time entertained a very low and contemptuous opinion of all personal estate, which they regarded only as a transient commodity. The amount of it, indeed, was comparatively very trifling, during the scarcity of money and ignorance of luxurious refinements which prevailed in the feudal ages. Hence it was that a tax of the 15th, 10th, or sometimes a much larger portion of all the movables of that subject was frequently laid without scruple, and is mentioned with much unconcern by our ancient historians, though now it would justly alarm our opulent merchants and stockholders. And hence likewise may be derived the frequent forfeitures inflicted by the common law of all a man's goods and chattels for misbehaviors and advertencies that at present hardly seem to deserve so severe a punishment. Our ancient law books, which are founded upon the feudal provisions, do not therefore often condescend to regulate this species of property. There is not a chapter in the Briton or the Mirror that can be fairly be referred to this head, and the little that is to be found in Glanville, Bracton, and Fleta seems principally borrowed from the civilians. But of later years, since the introduction and extension of trade and commerce, which are entirely occupied in this species of property, and have greatly augmented its quality and, of course, its value, we have learned to conceive different ideas of it. Our courts now regard a man's personality in a light nearly, if not quite equal to his realty. and have adopted a more enlarged and less technical mode of considering the one than the other, frequently drawn from the rules which they found already established by the Roman law, wherever those rules appeared to be well grounded and opposite to the case in question, but principally from reason and conveyance, adapted to the circumstances of the times, preserving withal a due regard to ancient usages and a certain feudal tincture, which is still to be found in some branches of personal property. But things personal, by our law, do not only include things movable, but also something more, the whole of which is comprehended under the general name of chattels, catala, which Sir Edward Coke says is a French word signifying goods. And this is true if understood of the Norman dialect, for in the grand costumier we find the word chattels used and set in opposition to a fief or feud, so that not only goods, but whatever was not a feud, were accounted chattels. And it is, I apprehend, in the same large, extended negative sense, that not sufficiently comprehensive to take in everything that our law considers as a chattel interest. For since, as the commentator on the costumier observes, there are two requisites to make a fief or heritage, during as to time, and immobility with regard to place. Whatever wants either of these qualities is not, according to the Normans, an heritage or fief, or according to us, is not a real estate. The consequence of which, in both laws, is that it must be a personal estate or chattel. Chattels, therefore, are distributed by the law into two kinds, chattels real and chattels personal. Chattels real, saith Sir Edward Coke, are such as concern or favor of the realty, as term for years of land, wardships, and chivalry, while the military tenures subsisted. The next presentation to a church, estates by statute merchant, ho, statute staple, illegit, or the like, of all which we have already spoken. And these are all called real chattels, as being interests issuing out of or annexed to real estates, of which they have one quality, viz., immobility, which denominates them real, but want the other, viz., sufficient legal, indeterminate duration, and this want it is that constitutes them chattels. The utmost period for which they can last is fixed and determinate, either for such space of a time certain, or till a particular sum of money be raised out of such a particular income, so that they are not equal in the eye of the law to the lowest estated freehold, at least for another's life. Their tenants were considered upon feudal principles as merely bailiffs or farmers, and the tenant of the freehold might at any time have destroyed their interest till the reign of Henry VIII. A freehold, which alone is a real estate, and seems, as has been said, to answer to the fief in Normandy, is conveyed by a corporal investiture and livery of season, which gives a tenant so strong a hold of the land that it never after can be wrested from him during his life, but by his own act of voluntary transfer or of forfeiture, or else by the happening of some future contingency, as in estates pure outre vie, sesta que vie, and the determinable freeholds mentioned in a former chapter. And even these, being of an uncertain duration, may by possibility last for the owner's life, for the law is not presuppose the contingency to happen before it actually does. The law will not presuppose the contingency to happen before it actually does. Until then, the estate is to all intents and purposes a life estate, and therefore a freehold interest. On the other hand, a chattel interest in lands, which the Normans put in opposition to a fief, and we to freehold, is conveyed by no season or corporeal investiture, but the possession is gained by the mere entry of the tenant himself, and it is sure to expire at a time prefixed and determined, if not sooner. No, they didn't. But we're dealing with feudal law. Feudal law is military conquest, so they're not going to tell people. Thus, a lease for years must necessarily fail at the end and completion of the term. The next presentation to a church is satisfied and gone the instant it comes into possession. That is, by the first avoidance and presentation to the living. The conditional by the living. Where did I go? The conditional estates by statutes and illegit are determined as soon as the debt is paid. And so guardianships and chivalry were sure to expire the moment that the heir came of age. And so guardianships and chivalry were sure to expire the moment that the heir came of age. And so guardianships and chivalry were sure to expire the moment that the heir came of age. And if there be any other chattel real, it will be found to correspond with the rest of his essential quality, that its duration is limited to a time certain, beyond which it cannot subsist. Chattels, personal, are properly and strictly speaking things movable, which may be annexed to or attendant on the person of the owner, and carried about with him from one part of the world to another. Such are animals, household stuffed, money, jewels, corn, garments, and everything else that can be properly put in motion and transferred from place to place. And of this kind of chattels it is that we are principally to speak in the remainder of this book, having been unavoidably led to consider the nature of chattels real and their incidents in the former chapters which we were employed upon real estates. That kind of property being a mongrel amphibious nature, originally endowed with one only of the characteristics of such each species of things, the immobility of things real and the precarious duration of things personal. Chattel interests being thus distinguished and distributed, it will be proper to consider, first, the nature of that property or dominion to which they are liable, which must be principally, nay, solely, referred to personal chattels, and secondly, the title to that property, or how it may be lost and acquired. Of each of these in its order. Yeah. So, any questions on that so far? Yeah, double right. They're the mortgage company is considered owner in fee simple. Well, kind of. They're considered the owner in fee tail. You're considered the owner in fee simple, but the problem is that they have right of remainder. Yeah, nah, that one is real good. I like Blackstone's commentaries. They tell you how things came about. Owner in fee tail means an owner. So you have let's just say, yeah, so the owner in fee simple is considered the head or the feud, the one with head rights, the one with livery in possession. So that's the one that has the, supposedly higher title, 9/10 title. The owner in fee tail is considered a residuary beneficiary. They only receive what's left after either the death of the fee simple owner or some type of reversion or unpaid balance of dues, something along those lines. But that's the owner in fee tail is essentially the one that gets it after that length of time and all that, and only has a contingent, remainder interest in the property. So the bank, the mortgage company and all that, they're considered the owner in fee tail, which is why they put you owner in fee simple. But You don't just want to be owner in fee simple and lose, the ownership entail of the estate. Yeah, fee tail is the scraps. Yeah, so that's what that's talking about. So for it to be a perfect title, you actually have to be in possession of it as well. Well, yeah, if you don't, you got somebody else controlling your head or controlling your tail. Yeah, that's really what it is. I mean, hey yo, hey yo, oh man, that was wild. That was so wild. The whole dang body. Yeah, that's true though. That's true. You want the entire chattel interest. And the lands, tenements, and hereditaments. Mortgage. Gauge meaning measure, and mort meaning death. It's a measure of death. How much debt or death can you take on and still continue? That's wild funny. So yeah. So I'll continue. So this is Blackstone's Commentaries of the Laws of England, book Grant and Contract. We are now to proceed, according to the order marked out, to the discussion of two of the remaining methods of acquiring title to property and things personal. Oh, I'm about to cover that, so. Which are much connected together, and answer in some measure to the conveyances of real estates, being those by gift of grant and by contract, whereof the former vests a property in possession, the latter a property in action, or an interest. So that's why you're not supposed to like gifts. Gifts, then, or grants, which are the eighth method of transferring personal property, are thus to be distinguished from each other. That gifts are always gratuitous, grants upon some consideration or equivalent, and they may be divided, with regard to their subject matter, into gifts or grants of chattels real, and gifts or grants of chattels personal. Under the head of gifts or grants of chattels real may be included all leases for years of lands, assignments, and surrenders of those leases, and all other methods of conveying an estate less than a freehold, which were considered in the 20th chapter of the present book, and therefore need not be here again repeated. Though these very seldom carry the outward appearance of a gift, however freely bestowed, being usually expressed to be made in consideration of blood or natural affection, or of 5 or 10 shillings nominally paid to the grantor, and in the case of leases, another reserving a rent, though it be but a peppercorn, many of which considerations will, in the eye of the law, convert the gift, if executed, into a grant, and if not executed, into a contract. Grants or gifts of chattels personal are the act of transferring the right and possession of them, whereby one man renounces and another by immediately acquires all title and interest therein, which may be done either in writing or by word of mouth. Although oral trusts are not worth the paper they're printed on, so they're not worth anything, attested by sufficient evidence, of which the delivery of possession is the strongest and most essential. But this conveyance, when merely voluntary, is somewhat suspicious, and is usually construed to be fraudulent, if creditors or others become sufferers thereby, and particularly by Statute 3 of Henry VII, all deeds of gift of goods may be made in trust to the use of the donor shall be void, because otherwise persons might be tempted to commit treason or felony without danger of forfeiture, and the creditors of the donor might also be defrauded of their rights. Yeah, that makes sense. And by Statute 13 Elizabeth, every grant or gift of chattels as well as lands with intent to defraud creditors or others shall be void as against such persons to whom such fraud would be prejudicial, but as against the grantor himself shall stand good and judicial, but as against the grantor himself shall stand good and effectual. And all persons partakers in or privy to such fraudulent grants shall forfeit the whole value of the goods, one moiety to the king and the other moiety to the party grieved, and also on conviction shall suffer imprisonment for half a year. A true and proper gift or grant is always accompanied with delivery of possession, and takes effect immediately, as if A gives to B 100 L or a flock of sheep, and puts him out of possession of them directly. It is then a gift executed in the donee, and it is not in the donor's power to retract it, though he did not without any consideration or recompense, unless it be prejudicial to the creditors or the donor who are under any legal incapacity, as infancy, coverture, duress, or the like, or if he were drawn in, circumvented, or imposed upon by false pretenses, ebriety, or surprise. But if the gift does not take effect by delivery of immediate possession, it is then not properly a gift, but a contract. And this a man cannot be compelled to perform, but upon good and sufficient consideration, as we shall see under our next division. A contract, which usually conveys an interest in merely an action, is thus defined: an agreement upon sufficient consideration to do or not to do a particular thing. Be contemplated in all contract: the agreement, the consideration, and the thing to be done or omitted, or the different species of contracts. First, then, it is an agreement, a mutual bargain or convention, and therefore there must at least be two contracting parties of sufficient ability to make a contract, as where A contracts with B to pay him a sum of money, and thereby transfers a property in such sum to B, which property is however not in possession, it could not be transferred to another person by the strict rules of the ancient common law. For no chosen action would be assigned or granted over, because it was thought to be great encouragement to litigiousness, if a man were allowed to make over to a stranger his right of going to law. But this nicety is now disregarded, though in compliance with the ancient principle, the form of assigning a chosen action is in the nature of a declaration of trust, and an agreement to permit the assignee to make use of the name of the assignor in order to recover the possession. Therefore, when in common acceptation a debt or bond is said to be assigned over, it must still be sued in the original creditor's name, the person to whom it is transferred being rather an attorney than an assignee. I hope everyone understood what that said. Oh, yeah. That makes sense. But the king is an exception to this rule, for he might always either grant country. Almost all personal property must necessarily lie in contract, will protect the assignment. Yeah. Declaration of trust, something they never did. No, they did. But the form of trust was not. It was a form of escrow. It wasn't a form of beneficial trust for us. At least not until you reconstrue it. This contract or agreement may be either express or implied. Express contracts are where the terms of the agreement are openly uttered and avowed at the time of the making, as to deliver an ox or 10 load of or 10 load of timber, or to pay a stated price for certain goods. Futures contract. Or the law presumes that every man undertakes to perform, as if I employ a person to do any business for me or perform any work. The law implies that I undertook or contracted to pay him as much as his labor deserves. If I take up wares from a tradesman, without any agreement of price, the law concludes that I contracted to pay their real value. And there is also one species of implied contracts, which runs through and is annexed to all other contracts, conditions, and covenants, viz., that if I fail in my part of the agreement, in short, almost all of the rights of personal property, when not in actual possession, do in great measure depend upon contracts with one king or another, or at least might be reduced under some of them, which indeed is the method taken by the civil law, it having referred to the greatest part of the duties and rights which it treats of to the head of obligations ex contractu and quasi ex contractu, so out of the contract or arising out of the contract or arising out of the quasi contract. A contract may also be either executed as if A agrees to change horses with B and they do it immediately, in which case the possession and right are transferred together, or it may be executory, as if they agree in possession but in action, but a contract executed which differs nothing from a grant conveys a chosen possession. A contract executory conveys only a chosen action. Yeah, implied is kind of more like operation of law. It's not what you want, since a lot of things are not common right now. Having thus shown the general nature of a contract, we are secondly to proceed to the consideration upon which it is founded, or the reason which moves the party contracting to enter into the contract. It is an agreement upon sufficient consideration. The civilians hold that in all contracts, either express or implied, there must be something given in exchange, something that is mutual or reciprocal. This thing, which is the price or motive of the contract, we call the consideration, and it must be a thing lawful in itself, or else the contract is void. A good consideration, we have before seen, is that of a blood or natural affection between near relations, the satisfaction accruing from which the law esteems an equivalent or whatever benefit may move from one relation to another. This consideration may sometimes be set aside, and the contract become void, when it tends in its consequences to defraud creditors or other third persons of their just rights. But a contract for any valuable consideration, as for marriage, for money, for work done, or for other reciprocal contracts, can never be impeached at law, and if it be of sufficient adequate value, is never set aside in equity, or the person contracted with has then given an equivalent in recompense, and is therefore as much an owner or a creditor as any other person. These valuable considerations are divided by the civilians into 4 species. Yeah. Des, as when I give money or goods on a contract that I shall be repaid money or goods from them again. Of this kind are all loans of money upon bond or promise of repayment, and all sales of goods, in which there is either an express contract to pay so much for them, or else the law implies a contract to pay so much as they are worth. The second species is facio ut facias, as when I agree with a man to do his work for him, if he will do mine for me, or if two persons agree to marry together, or to do any other positive acts on both sides. Or it may be to forbear on one side in consideration of something done on the other, as that in consideration A, the tenant will repay his house, B, the landlord will both sue him for waste. Or it may be for mutual consideration that A will not trade Lisbon, B will not trade for Marseille, so as to avoid interfering with each other. The third species of considerations is facio ut des, when a man agrees to perform anything for a price, either specifically mentioned or left to the determination of law to set a value on it. And when a servant hires himself to his master for certain wages or an agreed sum of money, here the servant contracts to do his master service in order to earn that specific sum. Otherwise, if he be hired generally, for then he is under an implied contract to perform this service for what it shall be reasonably worth. The fourth species is do ut facias, which is the direct counterpart of the other, as when I agree with the servant to give him such wages upon him performing such work, which we see is nothing else but the last species inverted. For servus facit ut herus det and herus dat ut servus faciat. A consideration of some sort or other is so absolutely necessary to the form of a contract that a nudum pactum, or naked agreement, or an agreement to do or pay anything on one side without any compensation on the other, is totally void in law. Yeah, I think it was a name. A global mindset, I think it was a name. I don't know. So, and then a man cannot be compelled to perform it. As if one man promises to another sum of money, here there is nothing contracted for or given on one side, and therefore there is nothing binding on the other. And however a man may or may not be bound to perform it in honor or conscience, which the municipal laws do not take upon them to decide, certainly those municipal laws will not compel the execution of what he had no visible inducement to engage for, and therefore our law has adopted the maxim of civil law, that ex nudo pacto non oritur action. So out of a negative agreement, no action arises. But any degree of reciprocity will prevent the pact from being nude. Nay, even if the thing be founded on prior moral obligation, as a promise to pay a just debt, though barred by the statute of limitations, is no longer nudum pactum. And as this rule was principally established to avoid the inconvenience that would arise from setting up mere verbal promises for which no good reason could be assigned, it therefore does not hold in some cases where such promise is authentically proved by written documents. What's going on, David? Who's the grantor, the sestike, the queen, the mom, the stay, the mom? It's presumed to be you, but the problem is the mother and father did it on behalf as informant. But we were never legally seen as above the age of majority, so, and even though we are the grantor, someone has to act in our favor until we prove that. For if a man enters into a voluntary bond or gives a promissory note, he shall not be allowed to aver the want of consideration in order to evade the payment. For every bond from the solemnity of the instrument and every note from the subscription of the drawer carries with it an internal evidence of good consideration. Courts of justice will therefore support them both, as against the contractor himself, but not to the prejudice of creditors or strangers to the contract. We are next to consider thirdly, the thing agreed to be done or omitted. A contract is an agreement, upon sufficient consideration, to do or not to do a particular thing. The most usual contracts, whereby the right of chattels personal may be acquired in the laws of England, are 1. That of sale or exchange, 2. That of bailment, 3. That of hiring and borrowing, and 4. That of debt. Sale or exchange is a transmutation of a property from one man to another, in consideration of some recompense and value. For there is no sale without a recompense. There must be a quid pro quo. If it be a commutation of goods for goods, it is more properly an exchange. But if it be transferring of goods for money, it is called a sale, which is a method of exchange introduced for the convenience of man-king. I don't know what that's saying. Man-king, by establishing a universal medium, which may be exchanged for all sorts of other properties. Whereas, if goods were only to be exchanged for goods by way of barter, it would be difficult to adjust the respective values, and the carriage would be intolerably cumbersome. All civilized nations adopted, therefore, very early the use of money, for we find Abraham giving, quote, 400 shekels of silver, current money with the merchant, for the field of Machpelah. Though the practice of exchanges still subsists among several of the savage nations, but with regard to the law of sales and exchanges, there is no difference. I shall therefore treat of them both under the denomination of sales only, and shall consider their force and effect, in the first place, where the vendor hath in himself, and secondly, where he hath not, the property of the thing sold. Where the vendor hath in himself the property of the goods sold, he hath the liberty of disposing of them to whomever he pleases, at any time and in any manner, unless judgment has been obtained against him for a debt or damages, and the writ of execution is actually delivered to the sheriff. For then, by the statute of frauds, the sale shall be looked upon as fraudulent, and the property of the goods shall be bound to answer the debt, from the time of delivering the writ. Formerly, it was bound from the test or issuing of the writ, and any subsequent sale was fraudulent. But the law was thus altered in favor of the purchasers, though it still remains the same between the parties. And therefore, if a defendant dies after the awarding before the delivery of the writ, his goods are bound by it in the hands of his executors. If a man agrees with another for goods at a certain price, he may not carry them away before he hath paid them, for it is no sale without payment, unless the contrary be expressly agreed. And therefore, if the vendor says, the price of a beast is £4, and the vendee says he will give £4, the bargain is struck, and they neither of them are at liberty to be off, provided immediate possession be tendered by the other side. But if neither the money be paid, nor the goods delivered, nor tender made, nor any subsequent agreement be entered into, it is no contract, and the owner may be disposed of the goods as he pleases. But if any part of the price is paid down, if it be a penny, or any portion of the goods delivered by the way of earnest, which the civil law calls ara, and interprets to be emptionis venditionis contracti argumentum, the property of the goods is absolutely bound by it. And the vendee may recover the goods by action, as well as the vendor may the price of them. In such regard does the law pay the earnest as evidence of a contract, that by the same statute 29, I'm not sure who that is, no contract for the sale of goods to the value of 10, that sum of money or more shall be valid unless the buyer actually receives part of the goods sold by way of earnest on his part, or unless he gives part of the price to the vendor by way of earnest to bind the bargain, or in the part of the payment, or unless some note in writing be made and signed by the party or his agent who is to be charged with the contract. And with regard to goods under the value of 10 of that, I don't know if that's pounds or what, no contract of agreement for the sale of them shall be valid unless the goods are delivered within 1 year, or unless the contract be made in writing, signed by the party who is to be charged therewith. Anciently among the northern nations, shaking of hands was held necessary to bind the bargain, a custom which we still retain in many verbal contracts. A sale thus made was called hand sale, venditio per mutuum manuum complexionem, till in process of time the same word was used to signify a price, the price or earnest, which was given immediately after the shaking of hands or instead thereof. As soon as the bargain is struck, the property of the goods is transferred to the vendee, and that of the price to the vendor. But the vendee cannot take the goods until he renders the price agreed upon. But if he tenders the money to the vendor and he refuses it, the vendee may seize the goods, or have an action against the vendor for detaining them. And by a regular sale, without delivery, the property is so absolutely vested in the vendee that if A sells a horse to B for 10, and B pays him earnest, or signs a note in writing of the bargain, and afterwards, before the delivery of the horse or money paid, the horse dies in the vendor's custody, still he is entitled to the money, because by the contract the property was in the vendee. Thus may property and goods be transferred by sale, where the vendor hath such property in it himself. But property may also in some cases be transferred by sale, though the vendor hath none at all in the goods, for it is expedient that the buyer, by taking proper precautions, may at all events be secure to his purchase. Otherwise all commerce between man and man must soon be at an end. And therefore the general rule of law is that all sales and contracts of anything vendible in fairs or markets overt, that is, open, shall not only be good between the parties, but also be binding on all those that have any right or property therein. And for this purpose the mirror informs us, were tools established in markets, viz., to testify the making of a contract, for every private contract was discountenanced by law. Wherefore our Saxon ancestors prohibited the sale of anything above our value of 20 pence, unless in open market, and directed every bargain and sale to be contracted in the presence of credible witnesses. Market overt in the country is only held on the special days, provided for the particular towns by charter or prescription, but in London every day except Sunday is market day. The marketplace of spot But in London, every shop in which goods are exposed publicly to sale is market overt, for such things only as the owner professes to trade in. But if my goods are stolen from me and sold out of market overt, my property is not altered, and I may take them wherever I find them. And it is expressly provided by statute. First of Jacob, the sale of any goods wrongfully taken to any pawnbroker in London, or within 2 miles thereof, shall not alter the property. For this, being usually a clandestine trade, is therefore made an exception to the general rule. And even in market overt, if the goods to the property of the king, such sale, though regular in all other respect, will in no case bind him, though it binds infants, femme coverts, idiots or lunatics, and men beyond sea or in prison, or if the goods be stolen from a common person and then taken by the king's officers from the felon and sold in open market, still, if the owner has used due diligence in prosecuting the thief to conviction, he loses not his property in the goods. Okay, that's important. So I'm going to read that one again. And even in market overt, now public open market, If the goods be the property of the king, such sale, though regular in all other respect, will in no case bind him, though it binds infants, femme coverts, idiots, or lunatics, and men beyond the sea, or in prison, or if the goods be stolen from a common person, then taken by the king's officers from the felon, and sold in open market. Still, if the owner has used due diligence in prosecuting the thief to conviction, he loses not his property in the goods. So likewise, if the buyer knoweth the property not to be in the seller, or there be any other fraud in the transaction, if he knoweth the seller to be an infant or femme covert, not usually trading for herself, if the sale be not originally and wholly made in the ser or market, or not at the usual hours, the owner's property is not bound thereby. If a man buys his own goods in a fair or market, the contract of sale shall not bind him so as that he shall render the price, unless the property has been previously altered by former sale. And notwithstanding any number of intervening sales, if the original vendor, who sold without having the property, comes again into possession of the goods, the original owner may take them, when found in his hands, who has guilty of the first breach of justice, by which wise regulations, the common law has secured the right of the proprietor in personal chattels from being divested. For as far as the consistent with that other necessary policy, that purchasers bona fide in a fair, open, and regular manner should not afterwards be put to difficulties by reason of the previous knavery of the seller. But there is one species of personal chattels, in which the property is not easily altered by sale without the express consent of the owner, and those are horses, the sale of which, even in fairs or markets overt, is void in many instances where the other property is valid, because a horse is so fleet an animal, and the stealers of them may flee from far off in a short place, and be out of reach of the most industrious owner. All persons, therefore, that have occasion to deal in horses, and therefore liable sometimes to buy stolen ones, should do well to observe that whatever price they may give, or how long soever they may keep possession before it is claimed, they gain no property in a horse that has been stolen, unless it had been bought in a fair or market overt, nor even then, unless the directions be pursued that are laid down in the statute that in Elizabeth, by which it is enacted for 1 whole hour together, between 10 in the morning and sunset, in the open and public space used for such sales, and not in any private yard or stable, that the horse shall be brought by both the vendor and vendee to the toll gatherer and bookkeeper, down the price, color, and marks of the horse, with the names, additions, and abode of the vendee and vendor, the latter either property of the owner, if within 6 months after the horse is stolen he puts in his claim before the mayor or some justice of the district in which the horse shall be found. Vacant possession incumbent may impose a lien duty, a proprietor's hypothetical office. Sheesh. Yeah, it's the debt. But you have to know what property you're pledging. If you don't own the property, what property are you pledging? So yeah. So I think we'll just stick to that and see how it goes. So yeah, that's something there that most people aren't aware of. So land condemnation proceedings and annexation, foreclosure by eminent domain via taking title and then condemning it. That's something that has to be considered. Not just because I mentioned that rule does not mean it's actually the way to do it or reclaim it, because it said within 21 days. So it's been long after 21 days. But, you know, yeah. So, like I said, any questions, you know, comments on that? They granted administration of what they had in the French and Indian War to the administration under the Estates in the Continental Congress, which then subdivided it among the Union in commerce. So yes, they did grant land, and they retained an interest under the Cestui Act, which is acknowledged under the Treaties of Paris 1763 and 1783. And which is why it is presently referenced as the supreme law of the land, pursuant to the supremacy clause of the original organic constitution, which is essentially, you know, of no import today. Yeah. Absolutely. Any other questions? There's a lot. I know that old language is sometimes hard to decipher, but it's very wordy. Sometimes it's got a lot of prepositional phrases and a lot of conditional thoughts, a lot of implications. So as long as you kind of understand the implications of what they're getting at, and you can follow it. Yeah, the king is the arch treasure. Yeah, the Holy Roman Empire. The crown for the city of London. Yep. I'll probably go for like another 20 minutes. So, any other questions that y'all have? I know people still got their own things going on, and Like I said, any questions, and they can be guardian if we are devoid of the sovereign government. Well, they're construed to be the guardians because they claim that we are wards of the court. So as long as you haven't proven the age of majority, then you're still considered a ward. Allodial titles originally were all in allodium, and they were for the ownership of lands. They were based on hereditary rights by cast of lot to the sons of Noah, Ham, Shem, and Japheth. Shem, down the line begat Eber. Eber, down the line begat, Abraham, Isaac, and Jacob, who had the lands of the Americas and the Promised Land. The one and the same, So then Ham received the lands of Africa, thereof, and then Japheth received a lot of the other parts of, Russia and China and Europe, although there's been quite a bit of intermixing between Ham and Japheth, to the point where there are some intermingled peoples where it's hard to tell, and that because they're a mixture of both. But titles were always used there. Originally, they were in the Torah. It mentions how men began to call cities after the names of people, and originally they were named after a specific event or something that took place in that specific land, and they set a landmark thereof to remember. But no, it's not. Honestly, the allodial titles are not fraudulent. There are original peoples that can reclaim the land even if generations later. That's why it's called an owner in fee tail. But yeah, like I said, absolute, ownership of lands can only be dictated by what it says according to bloodline. So if you're not in the lands of your inheritance, you can't own it. You can't own the land in fee simple absolute. You just can't. You can't. Unless by private contract, it's not going to be recognized. Although, to be honest, there's no point to set up a marriage that can only be viewed by the state, because the state can only view persons. So if a man and a woman, under the doctrines of coverture, are one and the same because of the subsuming of a woman's person into a man upon marriage, then that means that a woman's legal identity is not allowed to subsist after the point in which she has become married a woman, because she belongs to her husband. So yeah, but yeah, and that's why it's like, but if that means that if a person still subsists, it's not a true marriage, it's a contubernium, which is the marriage of two slaves. It's only a joinder of estates. It's not a true marriage, and you never married the who you thought you did, because the whole relationship was built on a fraud and a lie. Which is why when people find this stuff out, it tends to have such a straining effect on relationships. So, and why would you vote in someone else's corporation that you don't have any interest in? You're not a majority shareholder, you're not all of that. So, I don't know why you would want to vote. Well, you get to vote, when you form your own business. You have the election of how you want to be taxed. That's the voting rights. The freedom of election. That's what it is. Whether you want to be taxed as a sole proprietary limited, or an incorporated entity, or incorporated unlimited, or what have you. Yeah. Any other questions? A widow is considered an executrix of her husband's estate a lot of times, unless an executor has already been appointed by the courts. Thank you, John. But an execute, it's one thing if even a woman isn't considered an owner in fee tail, because women could not own property, and the distinction is, to this day, women still can't own property anywhere in the world. The only difference being is that their estates can. And like I said, a marriage in today's terms is a marriage of two persons or estates. Meaning, because the woman's person was never properly subsumed and made legally one with the man, it was not a true and proper marriage under biblical terms. But yeah. Like I said, look up Condemn. Condemn is what a lot of places have. What's going on, Vaughn? No, you're winding up that trust. That trust you're winding up, they control that. That's a general bailment, or is a usufruct. You're the naked owner now. So you don't want to be a naked owner under a nudum pactum, or a naked contract, a naked agreement. You want to make sure that you correct your status to the point where, how you're holding your estate is not by personal ownership. Now you have something to hold it, a trust or something, It's not just sitting there on the open, just like that. You're good. But yeah, no, you wouldn't want to just use that same vessel that they're using to try to hold property. That doesn't work like that. Generally, no. If there's still property there's still property left to be administered. But, I don't know. You'd have to look at the time frames for the state. You'd have to get death certificates and authenticate them and, show that they're, a financial interest. And chattels real and personal. That's what they are. I don't know if it works like that, John, but it's an interesting concept. Yeah, remitter is definitely something to look into. Reversioner is definitely look into. Replevin, I'm not sure. Might be. But I'm more so looking to prove age of majority because that's what they keep saying everybody is. It's under the age of majority, so. Yeah, that's interesting that, yeah, realistically that's what it is, although I would wonder if they would recognize those facts. Yep. So I'll go about like 10 more minutes. Any last questions for the night? Voting rights, not rights. Interesting. No, the taxes were here already. Boston Tea Party was in protest. Although, to be honest, it didn't do much, but I don't know why people... Yeah. The Stamp Act, if I'm not mistaken, the reason why that they were protesting was because of the Stamp Act of 1765, which laid a tax on just about every type of import, as well as estates. So, yeah, I'm pretty certain that was the reason why. But like I said, did it do anything? Not really. Maybe at the time it might have been under necessity, but I mean, when you consider everything that's happened, yeah, it's... You gotta do it in court. It's kind of a little bit more complicated than people think. It's not exactly complicated per se, but there's more to it than people think. You know, you got to do the name change. You got to do the trusts, you know, the private foreign express trusts. You got to do recordings in the county, you know, assume names, you know, showing the reversionary name, the true name, surname, comma, given, upper and lower instead of first, middle, last, all caps. You got to do a bunch of things. And then eventually take it to Minnesota. Testatrix in New Zealand is real property. Well, testatrix is usually a female testator, or so they say. Yeah. Everything is a tax issue. Well, just wanted to let y'all know, thank y'all for staying on. I'm grateful to have y'all on here. If you need to set up a trust, let me know. BOI filings, beneficial ownership information filings from FinCEN have been reinstated, and you do have to file them by January 1st because the Court of Appeals reversed the decision of the District Court's ruling. So you do actually have to file it. That is something you need to jump on. Like I said, fines for that are steep. It's like $500 a day for penalties. And it's by the financial criminal or financial crimes enforcement network as part of the Department of the Treasury. So because it's dealing with taxation on entities and avoiding taxation or something, things like that, lawfully, they have jurisdiction, and it does actually fall under those different things. So yeah, you do need to file up with those reports. So like I said, let me know if you need a consultation. I do have some available. So like I said, fill out my contact form, and yeah, other than that, for the members of the workshop, we'll have a class tomorrow. Be going over some things we kind of went over in private chat in the chat earlier, not today, but I mean prior to the live. So other than that, thank you so much. Thank y'all. I am really grateful. I hope this has been enlightening as far as another piece, a little bit here and there. So thank you, John. So yeah, like I said, thank y'all so much for staying on, studying with me. All praises to the Most High. And this is B with 2B Fruitful Training Group, and I'll see you on the next one. Thank y'all, everyone. Good night. Absolutely, Roots. Absolutely.